Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about how you can fix your immigration status in the United States if you have an old order of deportation or removal and now you are married to a U.S. citizen. I receive many inquiries and many people come to me to talk about what they can do if they have an outstanding order of removal. They never left the country, but now they're married to a U.S. citizen. Well, first of all, of course, we need to look at all the factors together and see why there was an order of deportation. What was the reason? Whether the person never showed up for the hearing or the hearing took place and the person lost the hearing and there was some appellate history, depending on the situation. But in many situations, that would be the two plans that I would offer to people. Plan number one. First of all, when the person has an order of deportation, it means that in addition to now being illegally probably in the country prior to the order of deportation, if the person leaves the country, he or she will face two possible bars. Bar number one. Bar is an obstacle to return back to the United States. Bar number one. It's unlawful presence. If the person stayed in the United States illegally for longer than a year, he or she for 10 years cannot enter the country without a waiver. Bar number two. If the person has a removal order against him or her, she or he cannot enter the United States usually for 10 years without a waiver. And very often there is bar number three, and this is the toughest one. It's called the permanent 5-year bar in case the person missed their hearing and the court issued an order of removal without the person being in a courthouse when the person received adequate notice of the hearing and just simply didn't show up. So this is the toughest situation and I will address it in a separate video. But let's say that last bar is not applied to you. So you will have two choices. Choice number one. Your spouse, your citizen spouse, would have to petition for you, file a petition, I-130 petition. You probably will be called for an interview in connection with that petition because now, believe it or not, you're still technically in removal proceedings, even though your removal order was from a long time ago. And you will need to prepare for this because you do not want that old order of removal to be reinstated against you. That's a separate discussion what the reinstatement is, and you can find more information about that on my website. But let's say you were successful in this step and I-130 was approved. Then you have two options. You may try to reopen your old case, and very often the courts will reopen the case depending on what happened. Or you may choose a different route, route number two. You may choose to file two waivers. One waiver will waive a bar that applies to you because of the order of removal once you leave the country. It's called I-212 waiver. And the second waiver, it's I-601A waiver, will waive unlawful presence that you collected in the United States while you were here illegally. Which route to choose depends on many different factors. How successful you will be with waivers, if you believe that somehow maybe there are some situations when a motion to reopen will actually allow you to adjust your status without leaving the country at all. Sometimes it's possible, depending on the situation, but those are the most two common routes that the person will have in a situation with an old order of deportation and now they're married to a U.S. citizen. If you would like to learn more about different ways to adjust your status and different legal situations in connection with various immigration issues, please visit our website www.shautsova.com. Thank you.